Thanks a lot. It's a pleasure to be back in Kaunas. First of all, I'm going to speak just in a private capacity as a former attorney and from the perspective of academia. We're going to try to keep it short and concise. I'm going to talk about some general considerations and the legal situation in Germany before Professor Krodita is going to put the focus on Lithuanian law. The access to justice is emerging as a human right more and more. In the last months, there's been an increasing number of publications specifically dealing with the question of whether access to justice is a human right, which influences this has both on international as well as on national law. But often access to justice is limited because there's a lack of finances on the part of those who actually need access to legal services. Essentially, there are two ways in which we can deal with the problem of a lack of finances preventing access to justice. Either the state, which after all has a positive obligation to ensure access to justice, provides some sort of free or at least cheap legal advice, or the state relies on attorneys to actually fulfill this function, to provide the services which in fact are required to ensure fair access to justice, fair and equitable access to justice, regardless of personal finances, income, and so on. After all, attorneys also have a social responsibility which goes beyond the care for only the clients who can afford to pay high rates, but which is incumbent on them because of their status as attorneys. As we will see, these two basic models are not usually realized in a pure form, but often in a mixed version, combining the possibility of legal advice by the state or by attorneys, the latter working for a fraction of the price they would normally ask, or even completely for free. The alternative, of course, is pro bono work. Attorneys voluntarily working for free, without any requirement to do so on the part of the state. The question which we are going to ask is whether the social responsibility of the attorney is better realized through pro bono work or through institutionalized legal aid rules, in the sense that access to justice for those who cannot afford an attorney is made easier in one way or the other. In this context, there are two dimensions one has to look at. On one hand, the individual client. Is it easier or more effective for the individual client to go through a legal aid system or to receive pro bono legal advice? But we also have to look at all potential clients and answer the question which system provides the best or most effective access to justice for as many potential clients as possible. In Germany, an attorney is not a commercial actor. Rather, he or she is an independent agent in the administration of justice. The attorney is said to practice a so-called liberal profession, just like doctors, for example, physicians. Almost the same position is expressed in the Lithuanian legislation, stating that activities of advocates are not commercial in nature, but are restricted to the provision of legal services. Obviously, the reality, especially in large law firms, looks different, but the theory behind the work of attorneys is still the same. We as attorneys were not supposed to be motivated by commercial considerations, but are supposed to understand ourselves as agents of justice. This requires also that each and every client is treated with respect, and that every case is treated seriously, regardless of the potential income which can be generated through this case. In Lithuania, for example, Article 39 of the law on the bar states that an advocate must fairly discharge his or her duties, regardless also of the context of the individual case. Similarly, there's a very similar obligation on attorneys in Germany. The individual case must not matter for the quality of the legal service which is provided. Both legal systems, Germany and Lithuania, emphasize also the freedom of the attorney. After all, our profession is a free profession. Our function is not only in serving the client, but also as a safeguard of the citizens' participation in the law. This phrase, safeguarding the citizens' participation in the law, actually comes from paragraph 1 of the German Federal Code on attorneys. And it means nothing less than that the state has shifted the burden to ensure access to justice to the attorneys. The attorneys' activities serve the realization of a justice which is governed by the rule of law. In Germany, there are two types of legal aid. Legal aid being one of the two alternative models with which we can realize access to justice. We can make a distinction between legal advice aid, which happens in the pre-trial phase, or legal aid during a trial. We're going to put the focus more on legal advice aid in the pre-trial stage. To receive legal aid from an attorney, clients first have to go to the local court, fill out an income statement, provide a summary of their case, provide documentation, for example, regarding their obligations, if they have children, if their spouse is working, the rent they pay, things like that. After that, if they are deemed to have a case, the court will give them a document with which they can then go to a lawyer of their choice. They're not limited to a specific lawyer, but they can go to any lawyer in Germany with that document from the court, which basically obliges the attorney, to provide free legal advice. Free in the sense that the client pays a maximum of 10 euros per case. Only if the attorney is absolutely unable to handle the case, for example, because it's far outside his or her range of expertise, or if there are very extreme circumstances, only then can it be rejected. The principle, though, is that every attorney has the obligation to provide free legal advice if the applicant has thus been screened by the local court. The attorney then is paid more or less symbolic sum by the local court, but it's significantly less than the attorney would earn if he or she could bill regularly. To give you a basic idea of how much money an attorney earns for such a case, which can well take a couple of hours of work, is that there are about 500,000 cases every year. Of these almost 500,000 cases, about 14,000 applications are rejected. The rest is approved. But the court spent only a total of 25 million euros on these 500,000 cases, which makes 50 euros per case, plus the 10 euros you get from your client, makes 60 euros per case before taxes. Obviously, this is problematic from the attorney's perspective. After all, it takes time, and not only takes the attorney's time, you pay your secretary, you pay the rent for your office, and so on. From one perspective, one could think that it's almost a forced pro bono work, just that it's not voluntary. But on the other hand, this is the price attorneys pay. We as attorneys pay this price because we get something in return. We get a monopoly. We have a monopoly on providing legal services. And yes, it's not enough to have a certain level of education for it, but also this is part of the price we pay for this monopoly. The other alternative would be pro bono work. In Germany, pro bono work is in principle illegal, because there's a general rule that an attorney has to charge money for providing legal advice and for representing a client. There are a few exceptions. For example, if you provide legal advice to close relatives, your husband or your wife, sure. But in principle, free legal advice is forbidden. This rule, obviously, is broken very often. Of course, you can circumvent it by writing a bill to your client and knowing fully well that you will never be compensated. So de facto, pro bono work happens in Germany. But what is the difference? The difference here is that in pro bono cases, attorneys make use of their freedom, apart from the fact that they have to either break or circumvent the law on the minimum requirement that they have to charge. But they can make use of their freedom insofar as that they have the freedom to choose which cases to take. In legal aid cases, as an attorney, I don't have much of a choice. If the client comes to me, if he has the necessary documentation from the court, I cannot send him away, most of the cases. In pro bono cases, the client has the benefit of having an attorney who is actually interested in what's happening in the case, who has a specialist knowledge probably, who has a specialized interest in the outcome of the case in the subject matter. Therefore, from this perspective, at least in Germany, pro bono work benefits the individual client. If he or she needs very specific legal advice, the legal aid system, though, makes sure that as large as possible, a number of people actually gets at least some legal advice, regardless of the quality behind it.
Okay, I will continue the discussion. Now I will represent Lithuanian situation. As we already know, in Lithuania we also have state legal aid, and it's primary, secondary legal aid, and we will talk about secondary legal aid because it's provided by attorneys. And as you see on the slide, it could be partially compensated, 50% of expenses, or totally 100% of expenses. And as you see from the slide, number of applications is increasing every year, and number of satisfied application is more than 90%, which shows that a lot of people get their legal aid. And of course, selection is according to property and income of those people, and of course there are some exceptions in the law, providing that certain categories of people are able to get this help. For example, such as suffering serious mental disorders, seriously handicapped people, and other categories. And as you see, total costs are also increasing for the state legal aid, and in 2011 it had about 2% of total number of registered persons. So of course we may raise question why this legal aid is increasing, and there is no research made at the moment, but there may be various reasons. One of them, of course, economical crisis and a lot of poor people. Another reason is that more and more people get educated and they know their rights and they want to protect them. But of course in the future we'll see. Of course, now, in order to evaluate secondary legal aid, we need to get some data. Not many research is made, but still, as you see, availability of attorney is one of the criteria, and more than 65% of people get legal aid in less than 2 weeks, which shows that really rather good system and good functioning. Another criteria, of course, the quality of the documents attorneys are preparing in this system. And as you see, 78% are preparing on time. Of course, 15% are being late, which is not very well. Exception of prepared documentation, it means the quality of documentation, as you see, is also rather well. It's more than 80% as such accepted. And most interesting facts are opinion provided by legal institutions and the courts themselves about the quality of attorneys providing secondary legal aid, and as you see, advocates in general practice. And as you see from the slides, very interesting information is provided, that legal institutions are much more satisfied. Almost 70% of people think that attorneys providing secondary legal aid are of good quality, while only 40% of attorneys in general practice are of satisfactory, well, good quality. So the fact which needs to think. And of course, most interesting is to indicate the problems we have at the moment. First of all, it's unstable legal regulation. The first state legal act was enacted in 2000, and till now we already have 9 amendments to that law. And at the moment, this week, our parliament started to discuss the new version of state legal aid law, and changes, and rather big changes, were initiated by our Minister of Justice. Another interesting fact that at the moment we have lack of attorneys providing secondary legal aid. And as probably Lithuanians know, we have two lists of attorneys. In one list are attorneys providing constant legal aid, and at the moment there is number established, if I am right, 72 attorneys providing continuous legal aid. And in fact, we have only 66 people. So 6 attorneys we are in lack. And probably everyone thinks that attorneys working in secondary legal aid get very low income, that's why it's unpopular. And as you see from the slide, continuous attorneys get more than judges in the first instance. So it's not the money problem. Then, of course, we are thinking what other reasons could be. And one probably is that when attorney makes the contract for providing continuous legal aid, he is not allowed to get other clients and to provide other consultations. So he is as if not independent as a person, and who knows, maybe in some years he would like to return to his practice and every client will be lost. So probably there is a danger. Another a bit strange situation is the selection procedure. If attorney wants to get into continuous legal practice, he needs to take exam. And probably Lithuanians know that in order to become part of the bar, most persons need to take exam from the law. And now they are checked once more. And probably some attorneys don't want to go and to be checked once more, and probably what if they don't take the test? Because there are marks and there is passing grade, not passing grade, so it's a bit strange. Another strange fact is that attorneys on continuous legal aid need to take exam, while attorneys who are providing legal aid on a case basis, they don't need to take any exam and they are already on the list. So shortly about our, and one more maybe problem that there is no right for the client to choose the attorney. Of course, if he's very insisting, he may choose the attorney from the list and say, I would like this one. But he can't go like in Germany and to decide which attorney he would like his case to represent. At the moment, in the parliament, the changes are discussed, and one of them will be the right of the client to choose the attorney. And very shortly about pro bono services. It's opposite like in German. In Lithuania it's allowed, and our bar law, as you see from the slide, allows to provide legal services free of charge. But we have other problem, that it's not well developed and not many research made, and there are some legal firms in which web page there is announcement that they are providing legal aid pro bono, but in reality it's not functioning very well, it's just erasing. And of course I agree with my colleague that there is no one good model, and neither model, German or Lithuanian, is perfect, but of course we may learn from each other a bit, and if Lithuanian system is very formalized and, how to say, strict, on the other hand, we are allowed to provide pro bono services, and just the society, its understanding must change, and it's in our, as lawyers, hands to make some changes, I think. And as we remember, the first speaker in the morning, Professor Alexandravičius, he rightly said that attorney is not just a person providing legal services. We must understand that we are part of not judicial, but legal system, and that we need to also represent our clients and to help the justice to develop. And German model is more flexible, as if, because it allows clients to choose attorney, but I think if we have such a model in Lithuania, our attorneys will have various reasons how to say that it's impossible to handle the case. For example, that he's very busy and only in half a year the client will be served, or that he's not competent in that issue, etc., etc. So, neither system is perfect. Thank you for your attention.